So, welcome, good evening, good morning, good afternoon, wherever you are in the world, wherever you're joining us from. My name is Dr. Emily Jones, and I am a lecturer in the School of Law at the University of Essex. And I am, of course, the co-convener alongside my colleague, who you can see on the screen as well, Dr. Megan Wong of the Essex Public International Law Lecture Series. So it's my absolute pleasure to be your host for today's very exciting lecture, and we are very pleased to have with us Osvaldo Urrutia of the Universidad Católica de Valparaíso and Senior Legal Advisor also on Fisheries and Ocean Affairs to the Government of Chile. So very, very exciting speaker. And he is going to be speaking to the topic of international law and the problems with high seas fishing, looking at the future ahead. So Osvaldo was our guest speaker on the LLM and International Law of the Sea module here in the School of Law at the University of Essex, which is directed by Dr. Wong and is part of our new LLM in International Law, which is a postgraduate degree. We wanted to take this opportunity to thank Osvaldo on behalf of ourselves and our students for joining us in the virtual class this year. Our students were very lucky to have been taught by someone with such an array of expertise and practical experience. So I will hand over to Dr. Wong shortly to introduce our speaker properly, but before I do so, I just want to say a few words about the series itself. The Essex Public International Law Lecture Series is co-founded and co-convened by myself and Dr. Megan Wong. We are both international lawyers, but Dr. Wong is a formalist and I am a critical international legal scholar. And this series is really built upon our deep respect for one another's scholarship across these differences, as well as, very importantly, our friendship. The series therefore really prides itself on bringing these two important intellectual traditions of international law, formalism and international legal practice, and critical international legal theory together. And I think we can also safely say that we both have quite a passion for the law of the sea and environmental law issues, so this lecture is very much in that trend today as well. So this term we have already had a fantastic few lectures, and you can see more information about those on both our website and our YouTube channel, where you can watch the recordings if you missed them. And following today's event, we have upcoming lectures by Judge Eric Wennerstrom of the European Court of Human Rights and Professor Anne Orford of Melbourne Law School. And then rounding off the end of the year, we have a very special event with a series of speakers. So we will have Judge Maria Teresa Infanti Caffi of International Tribunal for the Law of the Sea, Professor Malgosia Fitzmaurice of Queen Mary University of London, Professor Fontini Pazarisis of the National and Kapodistrian University of Athens and Chair of the UN Human Rights Committee, and Professor Patricia Galvo Teles of the National University of Singapore, the Autonomous University of Lisbon, and also, of course, a member of the International Law Commission, where she is currently the chair of the drafting committee. So a particularly spectacular event to round off the series for this academic year. As a public international law focused lecture series, and as scholars in the field, Dr. Wong and I also wanted, particularly today, to take this opportunity to express our sadness upon hearing that Professor James Crawford, one of the most formidable scholars and practitioners of public international law of our times, passed away earlier this week. His passing away marks a great loss for the international law community, and we would like to express our gratitude for all that he did for the field. And we also send our condolences to his friends and family, and we know some of you are in the audience today as well. But of course, to go back to today's event and our fantastic speaker today, I would now like to take the opportunity to introduce you to Dr. Wong, who will be our chair. So Dr. Megan Wong is a lecturer in the School of Law at the University of Essex and the director of the LLM in International Law. She is a generalist public international lawyer and has advised states on a broad set of issues of international law, and has several specialist interests, including, as I already mentioned, the international law of the sea, so very topical for today. She holds a PhD in international law from Leiden University and is the author of a forthcoming monograph with Cambridge University Press entitled Responsibility of States and Individuals, Aggression at the International Criminal Court. So one to watch out for there. So without further ado, Dr. Wong, over to you.
Thank you, Dr. Jones, for the kind introduction. An excellent academic event is always a pleasure, but even more so when being with friends. And it's really a privilege to not only teach with you, but also to have co-founded and co-convened this series of excellent events with you. It is my pleasure for me to introduce our speaker, Osvaldo Rutia, for our lecture today. The topic of today's lecture is entitled International Law and the Problems with High Sea Fishing, the Future Ahead. Before I do that, let me go through a few housekeeping rules. The lecture will be for about 40 minutes, followed by a Q&A session. Please type out your questions in the Q&A box. I will read out your name and affiliations unless you opt to be anonymous. Feel free to type in your questions as we go along. So it is my pleasure to introduce Osvaldo. He is a senior legal advisor to the government of Chile in fisheries and ocean affairs and the former chair of the compliance for the Commission for the Conservation of Antarctic Marine Living Resources and the former chair of the South Pacific Regional Fisheries Management Organization Compliance. And he has also been appointed as the chair of the Commission of the South Pacific Regional Fisheries Management Organization. As we know, fishing on the high seas is one of the most challenging areas in practice. Osvaldo's service to the conservation of marine living resources in the high seas and the law of the sea is extensive, far-reaching, varied, and undoubtedly important. As we know, fishing is of vital importance to mankind for food security, subsistence agriculture, economic interests of states, as well as cultural and indigenous practices. In his role as the chair of the Commission of the South Pacific Regional Fisheries Management Organization, he represented the Commission at a dispute brought by Ecuador's objection against the Commission's decision on the allocation of jack mackerel before a review panel set up under the auspices of the Permanent Court of Arbitration in 2018. This is particularly of note as it is one of the few recent fisheries disputes solved before a third-party adjudication framework. If I could also echo Dr. Jones here to thank Osvaldo for being our guest speaker for our International Law of the Sea module at Essex Law School for the classes on fisheries as well as conservation of marine biodiversity beyond national jurisdiction, both topics of which he will touch upon in today's lecture. When Osvaldo was our guest speaker for the class on conservation of marine living resources on the high seas, he had just finished in his capacity as the chair of the Commission of the South Pacific Regional Fisheries Management Organization, where he was up until 4 a.m. across several nights, but still found the time in his busy schedule to Zoom with me to pre-record our lecture on the topic. This is dedication that really speaks to Osvaldo's commitment to the field, where not only does he play a role in assisting states to comply with their fisheries obligations and the peaceful settlement of fishery disputes, but also to teaching and sharing his cutting-edge practice with students. This is really an inspiration, and I note that many of his students from Chile had signed up for this lecture, braving the early hour of 6 a.m., and that is really a pleasure to see. Outside of fisheries and ocean affairs, Osvaldo has also served as Chile's advisor on treaty negotiations, including the Trans-Pacific Partnership Agreement, which was a trade agreement between Australia, Brunei, Canada, Chile, Japan, Malaysia, Mexico, New Zealand, Peru, Singapore, Vietnam, and the United States. But going back to the law of the sea, he has participated in negotiations for the UN General Assembly resolutions on sustainable fisheries, including those on the protection of vulnerable marine ecosystem and bottom fishing, as well as bilateral disputes such as the swordfish case, Chile and the EU. Osvaldo is a lecturer at Universidad Católica de Valparaíso and is currently a PhD candidate at Victoria University of Wellington, where he is supervised by Professor Campbell McLaughlin QC and Professor Joanna Mossop. It's a pleasure to see them both in the audience, as well as others from New Zealand here, having joined us braving a late night Zoom webinar. And now I hand over, so to speak, to our speaker. Apologies, Osvaldo. I think you're muted. Yeah.
Yep. Yes, that's correct. Thank you. Tēnā koutou, buenas tardes, Reino Unido. Good evening to everyone from Wellington, New Zealand. Thank you very much, Dr. Jones and Dr. Wong, for this kind and generous introduction. Through you, I would like to express my gratitude to Essex University for today's invitation. It is an intimidating audience we have today, I must say, but at the same time, I'm very excited to see so much interest in this topic. This talk is about the challenge of sustainability in high seas fishing. I have organized this 45-minute presentation into 3 parts. In the first one, I will describe the environmental impacts of high seas fishing on the marine ecosystem and remind you of the legal reasons why achieving sustainability in this activity has been so elusive. In the second part, I will unpack the legal deficiencies of the system from 2 perspectives. One on regulation and compliance, and another institutional. In the third and final part, I will offer some reflections on the limits and possibilities of multilateralism and international law in advancing sustainability on the high seas, including a brief reference to the current negotiations for the so-called BBNJ Agreement. May I please add 2 quick footnotes? The overall challenges of high seas fishing certainly exceed this talk. I will only refer to some of them, and mainly from an international law perspective. For example, I will not address other rather different driving forces behind the dire state of global fishing, such as government subsidies that contribute to overfishing and overcapacity. I will not cover the details of illegal, unreported and unregulated fishing, IUU fishing either, which often requires a specific regional analysis that exceeds the purpose of this talk. On the second footnote, there is plenty of legal substance for far deeper legal discussions and analysis on the issues that I will touch upon. However, I opted to limit them for 2 reasons. One is because I am mindful that our audience today include guests from other disciplines, such as marine scientists and biologists. And second, because I also want to offer a practical or applied perspective, which will often overlap with policy observations as much as legal ones. Let me now then move to the first part, the high seas challenge. When we think about negative environmental impacts of marine biodiversity and ecosystems, we barely visualize fishing. Instead, our mind picks up images of oil spills, vessel pollution, or plastic bottles floating in a gyre. And yet, fishing is the economic activity behind the most severe impacts on marine biodiversity and ecosystems on the high seas. We know and we do understand that fishing is an important activity to provide the world with healthy protein. However, as fishing is still done today in many regions, its negative impacts deserve much more attention, even as they occur every day out of sight in our seas. Let me illustrate this. The next one, please. Can you still hear me? Yep.
Yeah.
Yes. Okay. Thank you. I think I thought I lost contact. Okay. Well, let me illustrate this. The most obvious impact is the overexploitation of the targeted species themselves. This slide shows global figures from the last FAO report available in 2020. You see that the number of overfished stocks has increased from 10% in the 1970s, up on the left, to more than or nearly 35% today. Still, you might be optimistic to think, well, this is not so terrible. After all, we still have 65% of global stocks that are sustainable. Unfortunately, we have reasons to worry. These stocks depicted as sustainable are those within the maximum sustainable yield, the most common standard to manage the exploitation of fish stocks. It means the largest average catch that can be taken from a fish population in the long term under constant environmental conditions. So it means that one more fish out of the water and the stock is overfished. And it is often the case that these numbers here do not account for illegal, unreported, and unregulated catches or IUU fishing. In other words, what I'm trying to say here is that this number that is depicted in orange on this slide might be higher, and the numbers in blue, so the sustainable stocks, might be lower. The point to make here is that the high seas are not the exception to these numbers. Many high sea stocks are overexploited, including pelagic, midwater, and deepwater species. The overexploitation of iconic species, including southern bluefin tuna and Atlantic bluefin tuna, has been widely reported. It has happened with deepwater species, such as orange-ruffy in the South Pacific, but also with pelagic stocks, like the blue whiting in the Northeast Atlantic 10 years ago, or today with Atlantic mackerel in the same area. Overfishing has many consequences, not only in the targeted species, but also in the trophic chain structure of the marine ecosystem, in the sizes of individuals, and triggering the so-called fishing down the food web. The consequences of fishing on targeted species are not the only impacts. Have a look at these examples. First, on your top left, bycatch. Bycatch is the taking of unintended species by a fishing vessel, like this loggerhead turtle in tuna operations. Bycatch occurs both in coastal waters and on the high seas, in legal and illegal fishing, including turtles, sharks, seabirds, and marine mammals, and more often than not, they are dead animals. Some regional regulations attempt to minimize bycatch, but it continues. Why? Because the system tolerates it and does not adopt stricter rules to stop it, like demanding more selective fishing gear. Next to your right, discards consist of unwanted fishing already dead, thrown overboard. Discards happen in legal activities. Why? Usually because a particular state, a company or vessel has a catch limit. They prefer to catch the big, nice and profitable fish and not discount damaged fish from their quota. So after the discard, they will continue fishing for the nice fish until reaching the catch limit. In the meantime, fish is wasted and unreported. Look now at the next picture, shark finning, an awful practice to get the shark fins only, so fishermen are not bothered to store the rest of the carcass on board. It is illegal in many areas of the high seas, but not in all of them. The next picture is, it illustrates the use of unselective and destructive fishing gear. These are gill nets. It is a form of bycatch. The example depicted here is in coastal waters, but this happens in the high seas too. Gill nets are indeed prohibited in many parts of the high seas, but are commonly used by illegal operators elsewhere, for instance, in Antarctic waters. This is not the only fishing gear that impacts the marine ecosystem. You have probably heard about bottom trawling. Although prohibited in many parts, it is still used in some high seas areas like in the South Pacific. The last photo on your left shows abandoned fishing gear. It happens often, mostly unintentional, but the scale is still significant. Perhaps between 10 and 15% of all marine plastic pollution might come from fishing gear, according to some recent studies. Worst, in some cases, the lost net continued to ghost fishing, adding to the environmental impacts. So in sum, these impacts are very real. They are often taken just as part of business as usual. Of course, illegal fishing does not even bother to comply with the environmental regulations in place. But unfortunately, in many places, the rules themselves are permissive or non-existent, or we have severe compliance issues. There should be no doubt that many illegal fishing activities on the high seas cause severe negative impacts on the marine ecosystem. Now, on top of the environmental impacts of high seas fishing, we have legal constraints that make up a systemic challenge. This systemic challenge is the consequence of an old rule in the law of the sea, which is very familiar to us all, the freedom of the high seas. There's nothing new in this, but I want to remind you of a few points early here in this talk. The freedom of fishing triggers three critical consequences for the system. One, as you can see on the light blue squares on the slides, lack of coastal jurisdiction means that conservation and management measures for the high seas must be negotiated and adopted by states in a multilateral framework. Currently, a decentralized system in the form of regional bodies, regional fisheries management organizations, or RFMOs. In practice, too, it also means that agreement must be reached by consensus. There is nothing intrinsically wrong with this, of course. Consensus is a fair rule that ensures legitimacy. However, it is also a fragile one. It translates into significant challenges to create law, most notably painful negotiations and accepting the lowest common denominator. In the third place, and equally, freedom of the high seas still means that exclusive jurisdiction of the flag state remains intact. The result is that compliance and enforcement on the high seas rely on the capacity and good faith of the flag state. But even when the flag state could have the means and will to act, monitoring, controlling, and surveillance on the high seas is a challenge in itself because the area is simply too vast. Before continuing, I would like to draw your attention on the brownish square on this slide. Let me quickly underline that some things have indeed changed concerning the freedom of fishing on the high seas. Freedom of fishing was historically understood, including in the Law of the Sea Convention, as freedom of access. This is no longer the case. The implementation of the 1995 UN Fish Stock Agreement and the changes in state practice over the last 2 decades confirm that fishing today must take place with flag states participating in RFMOs, either as members or as cooperating non-party states. However, this change doesn't modify the picture I have presented. Flag states operate as equals within the multilateral background of RFMOs, limited by the rule of consensus, and flag states are still the primary jurisdiction to reign on these fleets. So let me now move to the second part of this talk and to elaborate a little bit more on these 2 sets of issues or perspectives that represent what I have called the systemic challenge to achieve high seas sustainability. First, from the perspective of regulation and compliance, and then from an institutional one. Concerning regulation and compliance, I have just pointed that we have a regulatory challenge on the high seas. But are treaties part of the problem? Treaties are the building block of any multilateral regime. Do we have a treaty deficit or excess? Are they poorly designed? Or perhaps they lack ambition? There are many treaties whose provisions concern high seas fishing, some global, like the Law of the Sea Convention and the 1995 UN Fish Stock Agreement, and we have others, many more regional ones. Are they part of the problem or the solution? I want to make 2 points here. The first point concerns the most important of these treaties, the Law of the Sea Convention. It might seem heretical to confront it, but I think we should admit that the Law of the Sea Convention provisions on high seas fishing have always been insufficient to tackle the problems of the day. They are long outdated in many respects, including the use of the maximum sustainable yield as an exploitation target, the lack of precaution, and the scant role for RFMOs, to name just 3 significant issues. In my view, the best way to look at the Law of the Sea Convention today is simply as a starting point, not an ending one. My second point on treaty law is a little bit more cheerful. The good news is that treaty law has evolved despite the conservative framework of the Law of the Sea Convention. After the 1995 UN Fish Stock Agreement entered into force in 2001, many regional treaties have been amended or redrafted to account for the provisions of the UN Fish Stock Agreement. For example, the North Atlantic Fisheries Organization, NAFO, and the Inter-American Tropical Tuna Commission, ITTC. Equally, younger organizations emerged in the 2000s with quite progressive treaty text, like the International Commission for the Conservation of, like the Western and Central Pacific Fisheries Commission, WCPFC, the South Pacific RFMO, and the North Pacific Fisheries Commission, to name a few. There are still exceptions. One is ICAT, the International Commission for the Conservation of Atlantic Tunas. Another one is the Northeast Atlantic Fisheries Commission, or NIAFC. Their treaty texts are old and outdated, but even in these regional organizations, their founding treaties are not the only or even the main reason for success or underperformance. In my view, treaty law is not why the system is not delivering, at least from an environmental perspective. In general, most of them offer a reasonable and sound framework to adopt specific measures to manage fishing, except, as I just said, these structural problems that I have just mentioned. So if treaties are not the problem, what are the challenges from a regulatory and compliance perspective? As generally as possible, in my view, there are two, the ones that I'm showing on the screen. Now, the first one is the lack of appropriate conservation and management measures, or in other words, the specific regulation under the applicable treaty. Despite progress in recent decades, there is a regulatory deficit on the environmental aspect of fishing regulations. The main reason is that RFMOs have been created as fishing organizations to manage fishing interest. This idea of greening RFMOs is often alien or unnatural to these epistemic communities. It has taken time to advance these changes in their decision-making, especially when done by consensus. In short, it is easier to adopt measures to fish rather than agree on those to address bycatch or to force states to bring observers on board, to give just two examples. And second, there is a structural deficit in addressing compliance. Ensuring compliance on such a vast space as the high seas has always been complicated. But in addition to the operational challenge of the high seas, the rule of the exclusive flag state jurisdiction doesn't help. Regulations to achieve compliance are lax. Think about the following. High seas vessels never carry an inspector with them, and only exceptionally, they might bring a scientific observer on board, a person who is not an inspector anyway. The same applies to critical activities at sea, like transshipment, or the lack of regulations facilitating the use of satellite reporting, VMS, more publicly available. In addition, too many flag states, both from developed and developing countries, continue to show an alarming lack of capacity or interest to apply adequate sanctions against their nationals when they are involved in non-compliance incidents. So, in addition to the regulatory and compliance perspective that I just offered, the second set of issues representing what I've just called the systemic challenge to achieve high seas sustainability concerns the institutions that manage high seas fishing. In this slide, you can see the map of RFMOs, these regional bodies that manage high seas fishing. On your left, you have the 5 so-called tuna RFMOs, ICAT, ITTC, IOTC, WCPFC, and CCSBT. And on the right, you see the 7 RFMOs plus CAMELAR, that is not technically an RFMO, but is considered in practical terms as such, that manage straddling stocks. So unlike marine pollution from vessels operations or dumping, where the IMO, the International Maritime Organization, is an important setup, or global multilateral environmental agreements like CITES, or the Bonn Convention that capture global attention, the task of adopting binding measures for high seas fishing falls upon these unglamorous, relatively small multilateral organizations called RFMOs, with obscure acronyms that say little of what they do. I want to be very candid here. In general, RFMOs have not covered themselves in glory. Historically, the management performance of ICAT, CCSBT, NAFO, and NIAFC, to name just a few, has been appalling. In a recent paper published in the European Journal of International Law just last year, Professor Jan Klavers invited his readers to reject the assumption that international organizations are inherently benign. Perhaps the work of RFMOs could fit into this description. Just for you to note, and I want to underline this very bluntly, the RFMOs that I just mentioned, in them, the central actors and driving forces have been developed countries, not developing ones. And yet, at the same time, we need RFMOs. We cannot simply say they haven't done very well, have they, and just walk away. RFMOs play a critical role because high seas management must be regional. Besides, and in fairness, some RFMOs are performing well in some fields, like WCPFC and SPREFMO. And also, they face genuine challenges. Critically true, most of them are intrinsic to RFMOs dynamics because RFMOs themselves have been unable to solve such challenges in the first place. Just to give you 3 quick examples. First, the lack of appropriate funding to fulfill their goals, the lack of transparency and accountability, and third, the absence of binding dispute settlement mechanisms and the limited outcomes of their compliance evaluation procedures. So against this background, where do we go? Let me now move to the final part of this talk. The future ahead. There are no silver bullets against the high seas distressing environmental problems. For this reason, my goal today is more modest. I want to offer some reflections to trigger further debate and thinking on the role of international law in tackling the global pressing challenges I've described so far. First, let me rule out some radical solutions proposed elsewhere. Against the background of the first part, some voices have suggested stopping high seas fishing. The marine biologist Daniel Pauly, for example, from UBC in Canada, has recently advocated the closure of the high seas. Yes, a total ban. I will not discuss the fairness of this idea. My argument against it is simply practical. This is a radical solution that would hardly find any glimpse of support in fishing nations. In the meantime, we will waste time and we have no time to lose. And also, the devil's advocate could say, well, perhaps with some very few exceptions, some Pacific island states, New Zealand perhaps, Iceland perhaps, Norway perhaps, let's face it, fishing management in many exclusive economic zones is no better than on the high seas. Besides, there are examples of high seas sustainable fisheries. So why closing the high seas only? So instead of radical and unrealistic solutions, in this final part, let me try to outline 2 other approaches, plus a mention to the BBNJ process. The first approach I want to offer is the following. There is a long existing tension in international law between multilateralism and unilateral actions to achieve goals that many states may consider urgent or desirable. This tension is not necessarily bad, and it can sometimes trigger change indeed. In fact, it is unilateral conduct, or at least conduct from a few states first, that may activate the formation of customary international law. So this tension is relevant and sometimes even necessary. So let's focus on the one spectrum, one end of the spectrum, and multilateralism. The importance of multilateralism is always quoted or discussed. Like in many other areas that we call environmental regimes, in international relations, the multilateral treaty is the building block of the system. Under this framework, negotiations in good faith are the only way to forge consensus. In high seas fishing diplomacy, it means building up genuine consensus, bottom up, including the science behind fisheries management, which can take, I take it, years, and sometimes many years. The point I want to underline here is that the whole system is built upon trust, and trust takes years to exist, but it can be trashed in 1 or 2 wrong moves, maybe in 1 meeting. But once trust is broken, achieving consensus becomes nearly impossible, and disruption follows. Therefore, the process is as essential as the substance. There is a line between building up genuine consensus on the one hand and forcing a view of what is right and wrong from a group of like-minded states on the other. I think there is one telling example of what I'm trying to say. The discussions to designate marine protected areas in Antarctic waters under the Commission for the Conservation of Antarctic Marine Living Resources, CAMELA. Marine protected areas have become the battle of choice for certain actors and states. To be sure, I do not oppose MPAs as such. I believe they can be an effective tool to achieve environmental goals. As long as they are environmentally justified, there is a case to make. However, in my view, marine protected areas are not an end in itself. The Camelar experience on the negotiations for a marine protected area in the Ross Sea and Eastern Antarctica is a good example of the risk of not building up genuine consensus. In the end, we have the Ross Sea MPA, but at what price? Years of discussions turned into animosity and damaged the long-term relationship in Camelar partners. Camelar used to be the most successful organization with competence over fishery stocks. However, it is today at risks of being a dysfunctional organization. And one reason, in my view, is because there is no longer trust amongst its members. And yet, multilateral success is possible. It is never easy, but it is possible. The recovery of the jack mackerel fishery in the eastern South Pacific, managed by the South Pacific RFMO after years of overfishing, underlines that such achievement need time, trust, and yes, perhaps a modern convention to back up cooperation. There is another example that I would like to mention to highlight that change is possible and that international law has some tools to tackle global pressing problems. It is the case of non-members to RFMOs, including so-called flags of convenience, also known as unregulated fishing on the high seas. 20 years ago, some of you might recall, the main threat to sustainability in several RFMOs, including NAFO, NIAF, to an extent ICAT and CCSBT, were vessels flagged to non-members to these organizations. These operators, protected by the old notion of freedom of the high seas, understood as freedom of access, and also shielded by the principle of the Pacta Tertius, avoided multilateral regulations that state members to these RFMOs had agreed. And yet, over the early and mid-2000s, state members to regional fisheries management organizations in many latitudes developed new state practice rejecting, combating such free riders, treating them in practice under the notion of IUU fishing. So instead of accepting non-member activities as part of the freedom of fishing, instead, they closed their ports, applied trade sanctions, and exerted other diplomatic pressure to stop them. 20 years later, the non-member problem barely exists. There are very few flags of convenience still active on the high seas. I wanted to highlight this example because this kind of state practice is especially apt to deal with problems caused by extrinsic actors to RFMOs. Think today about fishing by vessels without nationality. They have been around for decades, and now they are a big issue in some regions, for example, in the North Pacific. As the international community has solved the problem of non-members, many private operators decided to go stateless. Is there any room here for a more robust approach to unilateral measures? I believe so. Unfortunately, many states with the operational capacity to undertake high seas inspections and seizures have a quite conservative understanding of international law on the matter, mostly approaching the issue based on Article 110 of the Law of the Sea Convention. One example, perhaps, are Australia and New Zealand of this, as judged by the legal justifications they offer to their high seas boarding and inspections in Antarctica a few years ago. So I think here in this area, there is room for change if the states are able to move forward the state practice. So let me now move to the other end of the spectrum and to focus on the right part of this slide. When to try unilateralism, or if you prefer, limited multilateralism. In other words, to what extent do we try multilateralism? When can we try unilateral measures and under what circumstances? Unilateral actions are always controversial for many reasons, legal, political, and for reasons of precedent and reciprocity. We need to be careful here, I admit, but I think there is a bottom line argument too. Unilateral measures are sometimes possible. For sure, they need certain conditions, at least a prima facie legal basis. But without unilateral measures, we would not have emerging practice. And without general practice, we will not have changes in international law, not least in customary law formation. So, where to look for possible experiences? I do not intend to judge in full or assess in full the European Union scheme on trade sanctions against IUU fishing, European Union Regulation 1008, known as the yellow and red card system, probably familiar to many of you here. It is a sensitive topic, and there is criticism in the way it has been implemented afterwards, not to mention its opacity. However, it is impossible to deny that it has merit, because it has made a difference in the behavior of several flag states. I think there are two lessons from this system that remain valid for future similar unilateral undertakings. First, the European Union's early efforts between adoption in 2008 and entry into force in 2010 to socialize and prepare the international fisheries community for what was coming, adding, therefore, some degree of legitimacy from the very outset. Second, the idea of an ongoing dialogue. Of course, not every subject matter where consensus fails can be taken up by unilateral measures. However, this example suggests that unilateral action sometimes can work despite the risks. There are another, perhaps less sensitive areas that should invite concerted states action when there is no regional or global consensus to move forward. I mentioned vessels without nationality just already. Another topic I believe is port state measures against illegal fishing committed on the high seas. There is consensus that the port state can accept or deny access to its facilities and also inspect the vessels. However, it is unclear currently whether the port state can take the direct action against vessels if the inspection shows IUU fishing, illegal activities. Compare this approach to Article 218, Paragraph 1 of the Law of the Sea Convention that recognizes the port state jurisdiction to initiate proceedings against discharge occurred on the high seas in violation of international standards established to the competent organization. At the time of the Law of the Sea Convention, RFMOs were not in the map as they are today and did not have the legitimacy that the Fisheries Agreement gave them afterwards. Moving state practice towards a standard like Article 218 of the Law of the Sea Convention should not be too controversial if the flag state does not act quickly. So let me move to the next or second approach, which I would like to suggest or maybe to offer today. And it concerns the actors. How can we try to influence the actor? And by this I mean RFMOs and states, because RFMOs are at the core of high seas environmental regulations, but they are conformed by states and indeed tightly controlled by them. Therefore, changing the way they work and regulate the high seas means addressing RFMOs themselves, but also member states. I see this and I'm trying to picture this on the left part of this slide. Imagine having two control knobs or control dials to play with. One to demand better performance from RFMOs and the other one to support them. At the same time, we have these knobs or these dial controls in two areas, multilaterally or at the RFMO itself, but also domestically with government. There is a spectrum of possible actions by combining them that we could apply to improve these actors' performance within the system. Some of them might need legal modifications, for example, in RFMO management measures, but others merely need changes in the current practice, perhaps at domestic level. So on the light blue circle on this slide, we have possible areas to apply these control knobs, as I've called. The first one is prioritizing the high seas. Even in many fishing nations, RFMOs are in the second or even third order or tier of priority. Lack of political attention translates into budget limitations and the lack of independent science in many RFMOs. Another, perhaps less remarkable but telling example is the composition of governmental delegations to RFMO meetings. Often high-rank fisheries people, but not too many from Ministries of Foreign Affairs, and no environmental officers. Even at the domestic level, I think we will all benefit from a more balanced, long-term view inside delegations. Balancing delegations, balancing existing bias, interests, and priorities inside national government, inside national delegations, and then submit proposals that could be discussed multilaterally. A second one is the need to improve accountability, transparency, and access to information. The compliance processes are a good example of this. They are too secretive, and information does not flow to the public. The key, in my view, lies here in accountability to our governments, not the RFMOs. And here is where the role of non-state actors is crucial. And I mean by this not only NGOs, but also, and critically, industry associations. There are good reasons for them to realize that sustainable fishing, accountability, and transparency play in their favor in the long term. A business that cannot ensure legitimacy is always at risk. And that legitimacy might be questioned because of the environmental impacts we have described today. We also need to rethink compliance, co-compliance, I like to say, enhance the role and capabilities of RFMO secretaries themselves to test flag state performance. Their capacity and independence is underused and under-budgeted. In addition, using new technologies to support legal evidence of non-compliance by flag state should be a priority. Unfortunately, I'm running out of time, and I would like really to move to the next slide to say something about the BBNJ project. So let me skip some comments that I had here to right away face this last point of my presentation today. The BBNJ project wants to protect marine biodiversity on the high seas. As we all know, there are 4 key areas, of which 2 are relevant to fishing: environmental impact assessment and, significantly, area-based measures, including the establishment of marine protected areas. So, considering the impacts of high seas fishing, the most critical question, in my view, is whether the agreement, the future BBNJ agreement, will include high seas fishing. But can we speak of marine protected areas without regulating fishing? I believe there can be no protection of biodiversity beyond national jurisdiction without having somehow high seas fishing in the treaty. I believe the agreement will have little value without including high seas fishing. And to do this, we must solve an essential tension. And this tension is the one between establishing marine protected areas by the future BBNJ Conference of the Parties and the current role of RFMOs. This is a sensitive issue that has never been straightforward. It was already unclear long before the negotiations started, and is still so. Some states have no interest whatsoever in setting up a new regime or affecting what RFMOs do today. Others, instead, want to superimpose, so to speak, the BBNJ regime to the existing regional fisheries management organizations one. The United Nations General Assembly Resolution 69/292, adopted in 2015, in its paragraph 3, recognizes that the process should not undermine existing relevant legal instruments and frameworks and relevant global, regional, and sectoral bodies. The meaning of this phrase is key, not undermine, but it's still unclear. If you look at the current draft text, Article 4, paragraph 3, the draft text seems to entail that not undermine doesn't mean necessarily not affecting or not influencing other regimes, including RFMOs. So I think there is a position there already. More generally, how could the relation between MPAs, marine protected areas, and RFMOs in the future biodiversity beyond national jurisdiction agreement work? As currently proposed in draft Articles 15, 16, 17, and 19C, the BBNJ Conference of the Party could decide on marine protected areas. So future members to the BBNJ agreement that are also members of the relevant regional body, the relevant RFMO, will have an obligation to implement the Conference of the Parties decision. But non-party states to BBNJ will not. In simple terms, it will all depend on participation in both regimes, BBNJ and RFMOs, and the capacity of the BBNJ parties to persuade non-parties whose vessels fish in RFMO regulated areas. This approach is not new. It's very simple. It's very similar to the United Nations fish stock agreements in Articles 8 and 17. Over time, the United Nations fish stock agreement showed its potential. As more states would become parties to the future BBNJ agreement, RFMO will implement the Conference of the Parties decision. The text still has many areas that need further clarification and perhaps better language. But in my view, it is a balanced approach that deserves to be pushed forward. So finally, and briefly to conclude, I have referred today to many issues, but I'll only to try to underline, highlight, summarize probably the key messages that I intended to convey and share today. One, on the way high seas fishing is done today. High seas fishing has severe negative impacts on the marine ecosystem, and we should not accept this simply as business as usual. More attention to this is needed. On the systemic challenge on high seas fishing, it is still real, not in terms of unlimited freedom of access, but the consequences of the absence of jurisdiction other than the flag states. An old problem, but still pretty real. On the evolution of regional treaty law, positive. In general, they are not part of the problem, but part of the solution. On the possibilities and limits of multilateralism, multilateralism is demanding and fragile, but possible, and it should continue to be the priority. On unilateral actions, they are not always undesirable, illegitimate, or counterproductive. They are actually sometimes necessary. However, they must be carefully pursued where conditions are right. On supporting and demanding more from RFMOs and governments to improve the performance of regional fisheries management organizations and state themselves as critical actors in the system, it is important to prioritize the high seas in domestic frameworks, as well as the need for accountability and transparency, where non-state actors can play a crucial role. And finally, on the BBNJ process, the BBNJ process and the future treaty will not be a remedy to all the problems on the high seas, but it's still a valuable opportunity. High seas fishing cannot stay out of this future treaty, at least concerning the designations of marine protected areas. So before closing, I wanted to finish with this picture, which to me represents the most precious and important value, human beings, especially those who work and make a living at sea. They should also be our priority. Thank you very much, and back to you, Dr. Jones and Dr. Wong.
Just to thank you for that fascinating and really interesting lecture. I really enjoyed thinking about the kind of different future mechanisms that you thought of as well. So yeah, really thank you so much for joining us. We know that it's very late in New Zealand as well, so you're a very committed speaker. And thank you to our audience. Yeah, that's it really.
Exactly. Thank you, Osvaldo. You're very, as Dr. Jones was saying, you're a very committed and dedicated speaker, not just for our series, but also for obviously for the field. And really, if we could also just, take the opportunity to thank you for your service to international fisheries, the high seas, the dispute settlements, the compliance, for everything that you've done and all the great things you'll undoubtedly do.
Thank you very much, Dr. Wong and Dr. Jones and all the audience that have attended today. I really appreciate your comments and your feedback and your questions, and hopefully we can do this at some point face-to-face. Thank you so much and have a great day over there in the UK.
Thank you. Bye, everyone.